Yes, Mr. Hungwe, we welcome you back to the interview room. I'll ask you the first question. It has two parts. The first part, what does the principle of inherent jurisdiction entail? Second part, give 3 instances where the inherent jurisdiction of the High Court is ousted.
Thank you, Chief Justice. My understanding of the principle of inherent jurisdiction is that it entails the inherent power of the High Court to preside over matters and to determine its processes, and in so doing, to the power to develop the common law, the power to develop customary law in the interests of justice. The inherent jurisdiction of the High Court is provided for in the Constitution in terms of Section 167 of the Constitution, if I'm not mistaken. It is a power that is vested in all superior courts, the High Court, the Supreme Court, and the Constitutional Court. So it affords the court to hear and preside over all matters that may be presented before it and over all persons that may appear before it in the interests of justice. The inherent power of the High Court may be ousted in 3 instances as follows. In terms of the doctrine or principle of mootness, whereby we are saying that a dispute that has been presented before the court no longer presents any dispute for determination. There no longer is any dispute between the parties. Usually this happens or occurs in instances where factors outside the record may have taken place which results in the dispute being overtaken by events. A case in point would be that of Eric Ndewere versus the President, where the court held that the dispute that was presented before the court had been overtaken by events and had become moot, and as a result the court declined to exercise its jurisdiction over that matter. So the first instance relates to mootness. The second instance arises in terms of the principle of ripeness. The underlying issues relating to the principle of ripeness are that the court ought to decline its jurisdiction in instances where a litigant or a party has approached the court in instances where the harm or injury that is complained of and which is the subject of the litigation has not yet occurred. In other words, there has not yet arisen a positive dispute for determination by the court. That is the second instance in terms of which the court may decline its inherent jurisdiction. The third scenario arises in terms of the principle of subsidiarity. In terms of the principle of subsidiarity, in instances where the Constitution makes provision for a right and there is subsidiary legislation which has been enacted to give effect to that right, and a party premises his claim or the litigation that is brought before the court on the constitutional provision, the court may decline its inherent jurisdiction on the basis that the party ought to explore other available remedies and avenues for ventilation of the claim and enforcement of the right. That, in short, Honorable Chief Justice, would be my response to that question.
The second question also has two parts. The first part, name two situations provided for under the High Court Rules 2021 in which an order or judgment of the court may be rescinded. What two requirements in respect of each type of case must a judge address before rescinding the order or judgment?
Thank you, Honorable Chief Justice. The High Court Rules 2021, in terms of Rule 27, provide for the procedure whereby a party may seek a rescission of a judgment granted in default. The second provision that relates to rescission or variation of default judgments is to be found in Rule 29 of the High Court of Zimbabwe Rules 2021. In relation to the procedure provided for in Rule 27, the two issues that a judge of the High Court ought to consider and make a finding on are as follows. First and foremost, in relation to Rule 27, the Rule 27 sub-Rule 2, my apologies, make provision for the court to make a finding on sufficient or good sufficient cause prior to making a determination to rescind a default judgment. Good sufficient cause is not defined in the rules per se, and it has been left for the courts to determine what it is that constitutes good and sufficient cause. In the matter of Stockhill, in the Stockhill matter, good sufficient cause was determined to be established in instances where a litigant has given, first and foremost, a reasonable explanation for the default, and having given a reasonable explanation for the default, the litigant demonstrates bona fides in the desire to have the judgment rescinded, and thirdly also demonstrates that he has a good defense to the main matter on the merit, which is arguable. Once a party establishes these factors, he may be entitled to having the order in question rescinded. This factor was also dealt with in the South African Supreme Court. South African Supreme Court in the matter of Jacob Zuma versus the Secretary for the Judicial Commission inquiry on state capture. So essentially, it is those factors that ought to be established by a party, and it is those factors that a judge ought to consider if they've been established prior to granting an order for rescission of default judgment in terms of Rule 27. In terms of Rule 29 of the High Court Rules 2021, It does not, like Rule 27, require the establishment of good sufficient cause. But what is sought to be established is that the default judgment in question was erroneously sought for or erroneously granted in the absence of a party who is affected by it. In instances where it is established that the judgment was granted in error, the court may rescind such a judgment. A judgment being rescinded in terms of Rule 29 may also be rescinded at the instance of the court itself. The judge may merely more to rescind a judgment whereby it has come to his or her attention that the judgment was erroneously sought for or erroneously granted. The trigger to the grant of rescission in that instance is the establishment of an error. Once it has been established that there was an error in seeking the judgment or granting the judgment, and the person seeking the judgment to be rescinded is affected by that particular judgment, then the court may exercise its discretion and grant such an application. A case in point would be the case of Grandjuli versus Grandjuli and another versus UDC, which dealt with this particular aspect. In short, Honorable Chief Justice, that would be my response to the question.
The third question has three parts. The first part, what do you understand by the concept of presumptive penalty? And the second part, what is the difference between a presumptive penalty and a minimum mandatory sentence? And the third part, state two effects the sentencing guidelines have had on the criminal justice system.
May I ask you to retake the third part, Honorable Chief Justice?
The first part.
The third part.
The first one.
Yes, Honorable Chief Justice.
What do you understand by the concept of presumptive penalty?
I had asked for the third part, Chief Justice. The third part.
Third part.
Yes, Honorable Chief Justice.
State two effects the sentencing guidelines have had on the criminal justice system.
Thank you, Honorable Chief Justice. My understanding of the concept of presumptive penalty is that it is first and foremost a creature of the recently promulgated sentencing guidelines. My understanding of it is that it represents the median or the middle point between the upper limits of a penalty that may be imposed on an offender in instances of aggravation, and the lower limits of a penalty that can be imposed in circumstances where there is mitigation. So the presumptive penalty is more or less of the middle ground, or the median. It is to guide the judicial officer when determining appropriate sentence. If there are no factors that justify a departure from the presumptive penalty, either mitigatory or aggravatory, it is the penalty that is to be imposed. That is my understanding of the concept of presumptive penalty. On the second part of the question, the difference between, maybe before I go to the second part, with regards to the first part, there is a judgment by Honorable Justice Mteredzi, that is the case of State versus Sixpence and others, which goes into detail in trying to explain this concept of presumptive penalty. Now, turning to the second part of the question, Honorable Chief Justice, the difference between a presumptive penalty and a mandatory minimum penalty arises in that, as I've already alluded to, a presumptive penalty is the median or middle point, or the general sentence that should be enforced in the event that there are no justifications upward or downward for movement away from the presumptive penalty. A mandatory minimum penalty, on the other hand, is a penalty that more or less takes away the discretion of the sentencing court in terms of what penalty to impose on an offender. My understanding of the concept of mandatory minimum sentence is in two parts. The first being the classical mandatory minimum sentence we have always had. For example, the mandatory minimum sentence relating to stock theft of bovines, which allows or which calls upon a sentencing court to look into, make an inquiry into, and make a determination on whether or not there are special circumstances that apply to the offender or to the circumstances of the commission of the offense that may justify the sentencing court from deviating from the minimum mandatory sentence. The second manner in which I understand minimum sentences relates to the situation that has been brought about by the recent amendment to Section 65 of the Criminal Law Codification and Reform Act, which deals with rape matters. The nature of minimum mandatory sentence that is brought in by the recent amendment, which was brought in by virtue of Criminal Law Codification and Reform Act number 10, the Amendment Act number 10 of 2023, is that it brings a class of mandatory minimum sentences that do not allow a judicial officer to make an inquiry into and a determination upon the existence or otherwise of special circumstances. So it is, in my view, a rigid form of mandatory minimum sentence, and the exigencies of this particular type of sentence have been dealt with by, again,
I asked you for differences, not for definitions only. Differences.
Indeed, I was going to go to that, my Honorable Chief Justice.
Just go to them. That's what I want.
The differences with the mandatory minimum sentence is that it limits or ousts the discretion of a sentencing court in as far as the sentence is to be imposed is concerned. A case in point is the case of State versus TG, which I was alluding to, which brings about a mandatory minimum sentence for rape matters, where in instances where, firstly, if there is aggravation that is found to exist, the sentence applicable would be imprisonment for life or a definitive imprisonment term for a minimum of 15 years, or in instances where there is no aggravation, a definitive imprisonment term of a minimum of 5 years with a ceiling of 15. So the distinction is on the discretion that is allowed. the mandatory minimum sentence takes away discretion, and in one instance it can only be exercised where there are special circumstances. In the second instance it cannot be exercised at all. The presumptive penalty still allows the court to exercise sentencing discretion, taking into account mitigatory and aggravatory circumstances that apply to the case. Turning to the third leg of the question posed, Honorable Chief Justice, two effects of the sentencing guidelines have had in the criminal justice system would be, first and foremost, it has brought a measure of consistency in as far as sentencing is concerned, in that the presumptive penalty acts as a guide to the kind of sentence that is applicable to each and every matter. The sentencing guidelines provide a detailed table or schedule of presumptive penalties and the relevant mitigatory or aggravatory factors that a judicial officer may take into account. The second effect that the sentencing guidelines have had is to also bring uniformity in the manner in which sentencing judgments are written, because the sentencing guidelines contain a form or format that judicial officers are to employ or when writing and dealing with sentencing judgments. So there is now a measure of uniformity in terms of presentation as a result. Those, in my view, Honorable Chief Justice, are the two effects that sentencing guidelines have had in the criminal justice system.
The last question has two parts. The first part, state three principles that govern the conduct of virtual hearing proceedings in the High Court. The second part, what is the role of a judge in the adoption of a virtual hearing as a proceeding in the High Court?
Thank you, Honorable Chief Justice. Three principles that govern the conduct of virtual hearings. The first principle, in my view, would be that whether or not the parties are to participate, to conduct their hearing virtually requires the parties' consent. So the first issue is that the parties themselves must consent to having their hearing conducted virtually. The second principle that would apply would be that when proceedings are held virtually, the witnesses that are to be called by a litigant and the litigant themselves, when the witnesses give evidence, this must be to the exclusion of the litigant. The litigant must not influence or have any way in which that they tamper with the manner of the evidence that is to be given by a witness who is to testify in virtual hearings. Thirdly, where parties are to hold a virtual hearing and witnesses are to testify, there must always be the presence of a police officer to oversee that process and ensure that parties do not interfere with the tendering of such evidence. Those, in my view, would be three principles that govern the conduct of virtual hearings. With regards to the second leg of the question relating to the role of the judge or a judge in the adoption of virtual hearings, the judge is to preside over pre-hearing processes that are preparatory for purposes of the hearing. And the judge is to ensure that the notifications relating to the hearing have been sent to the parties, and that parties are aware of the allotted time that the hearing is to be held, and the judge presides over the matter in a manner akin to how he would preside over a hearing that is being held physically. He must be in control of the processes and manage the manner that the parties make their submissions and the manner in which evidence is taken from the witnesses that may be appearing in the virtual hearing. In short, that would be my answer to that question, Honorable Chief Justice.
Thank you. I will now hand you over to the other commissioners for further questioning. Yes, DCJ.
Yes, thank you, CJ. Good afternoon, Mr. Hungwe.
Afternoon, Honorable DCJ.
I have one question for you, and that is concerned with what happens in the High Court. There are some circumstances in which a decision of the High Court requires more than one judge of the court, because generally judges in the High Court sit as a one-person bench. But there are exceptions, and my question is, what are these exceptions?
Thank you, Honorable Deputy Chief Justice. First and foremost, in instances where the court is sitting as an appeal court, a criminal appeal court to preside over a criminal appeal, the standard is that two judges sit as an appeal court. That would be one instance. The other would be when the court sits as a review court to review decisions of subordinate courts or tribunals. The general position again is that a review court is constituted by two judges. In some instances where a matter of importance may arise, the judge president, in terms of section 4 of the High Court, may, on request by the presiding judge, appoint another or other judges to sit and preside over that matter. So in my view, those are some of the instances in which a High Court may sit as a panel consisting of more than one judge.
Yes, thank you.
Yes, thank you.
Thank you, Chief Justice. Afternoon, Mr. Hungwe.
Good afternoon, Honorable
Just
Attorney
one
General.
question as well, and it's on subsidiary legislation. Is it possible that a statutory instrument can fall into disuse? And if so, under what circumstances? Can you be very brief in your response?
Thank you, Honorable Commissioner. Indeed, it is possible for a statutory instrument to fall into disuse. This would arise in instances where, for example, the matters that the statutory instrument was enacted to deal with have since been enacted as part and parcel of legislation emanating from Parliament, or have been incorporated into a statute that is passed by Parliament. The statutory instrument itself automatically falls into disuse, and the superior piece of legislation enacted by Parliament takes effect. Thank you, Honorable Commissioner.
Thank you, Chief Justice. Good afternoon, Mr. Ong.
Afternoon, Commissioner.
Yes, there is this issue of maintenance of that is involving you. So, do you confirm there is an order of maintenance against you?
Yes, Honorable Commissioner, I do confirm there is an order of maintenance that is what was handed down.
And you also confirm that there is this report that has been made to the police at, I think it's Roseville.
Yes, I
there's a
do
report
confirm
that
there is that report which was made, and the police did engage me in relation to that report, and I furnished the police with all the relevant documentation relating to the payments that relates to that maintenance claim, and upon that they indicated that they would go and make further inquiries to verify the payments, and if need be, they would revert back to me. But I can confirm that from the time that I furnished them with that information to date, which is a period of more than 2 months, they have not communicated with me.
So the matter remains open?
In
In the absence of them saying to you, we have investigated and finalized this, the matter remains open?
When they approached me, they indicated that they had not opened a CR in relation to that matter, but they were making an inquiry in terms of an inquiry register that they had opened relating to that matter.
So those inquiries are well, they have not been, the police have not come back to you to say they have concluded their inquiries. That's what I want to find out.
Indeed, they have not come back to me to indicate that, but I take it that they have not come back to me because they have satisfied themselves with the information I furnished that there is no matter that requires their further action.
Thank you, and thank you, Mr. Chief Justice.
Thank you, Honorable Commissioner.
Yes.
Thank you, Chief Justice. Just following up on that, Mr. Hungwe, does that domestic situation, would it not impact on on your office if you are appointed to have in your life a person who sues you for maintenance?
Thank you for that question, Honorable Commissioner. I do not think that that matter would negatively impact my capacity were I to be honored with appointment to the office of a judge to discharge my duties as a judge. In my explanation that I rendered to the Secretariat of the Judicial Service Commission, I did indicate that the very fact of the claim having been taken to the maintenance court in the first place arose out of a situation whereby the relationship between myself and the mother of the children in question had become toxic.
It had become very toxic.
In the sense that it was now affecting my marriage.
That's fine, but
Yes.
the fact is maintenance was overdue as at the date she went to the maintenance court. You've since made good.
Yes.
But as at the time she went to the maintenance court in November, you had not been maintaining your children.
I had been maintaining. Her issue with me was that I had cut off communications with her and insisted
Now, is that
on-
not a problem? Will she not continue to have that issue even if you are appointed? Should a judge have a woman in his life who has that kind of bitterness and toxicity?
My belief, Honorable Commissioner, is that as judges are first and foremost human beings, and as human beings, along the way, you make errors of judgment and errors in the manner that you deal with your issues. But I'm of the view that it would be a sad day if a mistake that is made by one person along the way were to haunt that person through their professional career. I believe that as long as I own up to my obligations as parent to these children and I meet their requirements, she should have and would not have any issues to raise with me.
You hope that she will not be coming back to you in the future with any kind of issue?
I anticipate that as long as the welfare of the children, unless she has got other motives that are ulterior, if her issue is welfare of the children, as long as the welfare of the children is catered for, that should then not be a cause for concern.
I have a different question though. You've just recently set up your own law firm in February 2023 and already you want to leave it.
Thank you for that question, Commissioner. Maybe for context, yes, I set up a law firm recently in February 2023. But prior to that, I had set up another law firm in league with others in September 2012. So it is not as if the setting up of a law firm is a new thing that I've just done. It was just that I parted ways with my former partners and established my current law firm. I also believe that I've made sufficient safeguards for the purposes of continuity of the law firm. The law firm that I currently preside over has got, inclusive of myself, 5 legal practitioners. Of those 5, 3 have completed their pupillage process that is required by the regulations of the Law Society and are due for appointment into partnership. So even if or were I to be honored with appointment to the office of judge, that would not disrupt the continuity of the firm, as there are persons that are able and capable to carry the legacy forward.
My last question, who nominated you for office of a judge?
I was nominated by David Makwara.
Okay, thank you. No further questions, Chief Justice.
Thank you, Honorable Commissioner.
Thank you, Honorable CJ. Mr. Hungwe, from your set of documents, I noticed you qualified with a law degree sometime in 2008. Is that correct?
Yes, Honorable Commissioner.
Have you subsequently considered it necessary to improve yourself by maybe acquiring a further qualification in law?
Yes, Honorable Commissioner, I did consider that, and I did enroll with the Midlands State University for their master's program, Masters in Constitutional and Human Rights Law. I have not yet completed the program. Outstanding is the dissertation.
Thank you.
Thank you, Honorable CJ. Yes, Mr. Hungwe,
Honorable
I'm
Commissioner.
just looking at your CV. What it reveals is that from 2008 to 2012, you were changing jobs every year. What was happening there?
Thank you for that question, Honorable Commissioner. That was a period of trying to find myself, so to speak. You will note that I started in private practice, and then briefly, for a brief period, and then it went into corporate practice. I was of the view that it may be what was in keeping with my aspirations at the time. But the stint that I had in corporate practice, which is about a year, revealed to me that for purposes of self-actualization, corporate practice at the time was not what I really wanted to do, which is what resulted in me reverting back into private practice. When I did revert back into private practice, I had the options of going back to my erstwhile law firm, which was Chinyama and Partners at the time, prior to my going into corporate practice. And I had the option of joining Mambo Sasa Legal Practitioners. I opted to join Mambo Sasa Legal Practitioners because it presented a new challenge. The manner or nature of practice at Mambo Sasa Legal Practitioners was different from that of Chinyama and Partners. The Mambo Sasa Legal Practitioners was more attuned to civil litigation, corporate transactions, and such related matters, which were in keeping with what I had just been doing in my past previous job in corporate practice. That was what motivated my decision to join Mambo Sasa Legal Practitioners at the time. I then left Mambo Sasa Legal Practitioners to go back to Chinyama and Partners at the specific request of the senior partner of Chinyama and Partners at the time, who had indicated that he had a desire to take some time off or some leave of practice, as he intended to enroll for a full-time studies for a master's program, which would have taken him out of the country for extended periods of time. So I went back to Chinyama and Partners specifically at the request of Mr. Chinyama, who at the time felt that by virtue of my stint at Chinyama and Partners, probably I had shown him sufficient capacity for him to have trust that I would be able to carry the legacy of his firm going forward. That is why there's that movement that you see on my CV, Honorable Commissioner.
Are you happy with the move that you want to make now?
Yes,
You're
indeed.
not going to find yourself in the same predicament where you leave soon after appointment, should you be appointed?
I believe my movement beyond Chinyama and Partners from the time that we established together with my colleagues Kadzere Hungwe Mandewere Legal Practitioners, that is in September 2012, I was with Kadzere Hungwe Mandewere Legal Practitioners for a period in excess of 10 years. That on its own, I believe, amply demonstrates the fact that I am now firmly footed and firmly rooted. In the past, when I was still seeking to find myself, I was still young, and I believe I've matured in that respect, which is why you see that I spent more than 10 years in league with other colleagues in Kadzere Hungwe Mandewere Legal Practitioners. I also see the position of a judge of a high court, in my view, as a measure of self-actualization. I see it as a measure of career development, and I also see it as an opportunity not only to grow as an individual, but also to grow within the judiciary itself. The judiciary appointment to the High Court bench does not present a ceiling on its own. So, in as far as my aspirations and ambitions are concerned, the judiciary presents ample opportunity for me to develop and grow within the system of the judiciary itself. Thank you, Honorable Commissioner.
Thank you, CJ. From your statement, you do indicate that a good name is worth more than gold. Maybe I will put it to you that when we say charity begins at home, does it not begin with our children? Look, I think I had the similar questions around maintenance. And I think the maintenance claim did come after almost 2 years of no interaction with the family and the children all being looked after. Confirm?
No, the children were being looked after. As I indicated in my response to the Executive Secretary of the Commission, when I cut off interactions with the mother of these children, I presented an option, an alternative. The alternative route of communication that I presented to her was that she should go through the medium of my wife. My wife would then, in the manner that she oversees the welfare of her own children, would do the same in as far as those children are concerned. And we worked with that.
Thank you for that. I think you answered. Secondly, I just wanted to verify the references that you've provided. Are they references of organizations that you've worked for, particularly the people that you've indicated on the CV?
These are, I am a person who is presently in private practice, and my interactions with individuals and entities in most instances relates to work that I do on their behalf as I represent them and as I represent their interests. So you would find that those are persons that are aware of my acumen and my capacities as a legal practitioner and as a legal professional, having engaged them and worked with them on that professional level.
Thank you, CJ.
Mr. Hungwe, good afternoon.
Afternoon, Commissioner.
Suppose you are appointed the judge of the High Court, and during a case that you are hearing, one of the lawyers representing the other party calls you for a private meeting with him, say in your chambers. How would you handle that?
Thank you for that question, Honorable Commissioner. I believe that question touches on one of the core and key tenets of a judicial officer and the judiciary at large, that of impartiality and also that of integrity. My duty to be impartial would require that I decline such an invitation, and my duty to be of utmost integrity at all times would equally require that I refrain and probably bring it to the attention of superiors that may be able to deal with the matter, for example, the office of the judge president. And in the event that such an approach is made, I may also ultimately consider the option of recusal, so as to maintain the issue of the perception of impartiality at all times.
Why would you consider recusal when you have not heard this other lawyer in private?
The very fact that a litigant would seek to influence the conduct of my duties would be a sufficient basis, in my view, for me to step aside.
No further question, Chief Justice.
Thank you, Chief Justice. Mr. Hungwe, good evening.
Good evening, Honorable Commissioner.
Yes. In your CV, you describe yourself as an avid scholar in constitutionalism. I will not finish the rest. What's your understanding of a scholar?
My understanding of a scholar, Honorable Commissioner, is a person who seeks knowledge in relation to a particular aspect. Each day of our lives is a learning curve. Each experience that we go through is a learning experience. Each encounter that enlightens you or broadens your knowledge or horizon of a particular subject matter is a learning process. So that is the perspective from which I was making that intimation, Honorable Commissioner.
Okay, thank you very much for that. I wanted to look at it differently because to me, there's no other evidence that shows your wide reading really in the areas that you describe. And no publications, no writings, I didn't see any. And so that's why I actually thought, how then do you describe yourself? Really as an avid, not just a scholar, but an avid scholar.
I understand the sentiments of...
Yes, so that may be a bit misleading. And then lastly, are you a registered student with Middle State University currently?
Presently, I am not registered, Honorable Commissioner.
The dissertation you spoke about, how do you submit it when you are not a registered student?
I had indicated in response to the question posed by Commissioner Hungwe that it is the outstanding issue in relation to my qualification for that particular program. I have not indicated that I am presently working towards it or that I am intent on submitting it anytime soon. I have taken a sabbatical in as far as that matter is concerned. That is why I am presently not a registered student.
And you are aware there are time limits?
Indeed, Honorable Commissioner.
Thank you. Nothing further, Chief Justice.
The issue of the order is a more clarification. You accept that you have the court order against you from the parents of your children $12 per month.
Yes, Honorable Commissioner, I do accept.
That order say that you should be paying that money by the of the month.